Good evening. This is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday, we do bring updates from 5 p.m. to 6 p.m. Central Time, and we do take live questions. Emily, what are the topics that we are discussing today?
Yeah, we have ongoing questions about these H-1B multiple registrations in this year's lottery. And so this week we wanted to talk about what happens if your H-1B actually gets revoked due to multiple filings. We're seeing that continue to happen for those H-1Bs that were approved last year. And we expect to see notice of intent to revoke for those that mistakenly get approved this year as well. So what can the employee do in that situation? We're also going to talk about job layoff survival guide. You know, although a lot of the big layoffs that have been talked about in the past have kind of slowed down, the job market's still a little tough. And so what are your options if you're nearing your 60-day grace period? You know, what can you do if you don't have that new job offer? How can a B2 change of status application help in that situation? We're also going to talk about the I-485 Supplement J. If your 485 is pending and you're changing employers, when do you need to file it? What has to be filed? Are there any consequences if you don't file it at the time you change employers? And then lastly, a very common question that we're getting these days is for those whose green card application is in process and then, you know, they're in H-1B or H-4 or L-1, L-2 status. They get their advance parole approved, and instead of going for visa stamping, they decide to travel and use the advance parole because it's much more convenient. So they've come back on advance parole and they want to know, what's my status now? Am I now using my EAD, or am I still in H-1 or H-4? Do I need to update my employer? Do I have to redo my I-9? So I'll answer all of those questions today.
Emily, on the main topic of notice of intent to revoke, we're receiving a lot of questions, a lot of intent to revoke, although the pace doesn't seem to have picked up right now as much as it's supposed to, because most of the intent to revoke we are receiving is the previous 2 years, but not for the current year at this point of time. We haven't seen the notice of intent to deny yet for this year, though. So, Emily, with regards to the note, what is the notice of intent to revoke? Can you explain that? What's the difference between RFE, notice of intent to deny, and what is notice of intent to revoke?
Yeah, so it all depends on when this is happening in the process. So if the H-1B has already been approved by the Immigration Service, and after the fact they determined that it was approved in error because they realized that this companies worked together to do multiple registrations, they will then have to issue a notice of intent to revoke. That's letting the company know that, hey, we approved this case. We think we approved it in error. We're giving you notice that our intention is to revoke this approval unless you prove to us that you qualify for it and there was no fraud involved in these multiple filings. So that's a notice of intent to revoke that happens after the H-1B is approved. You only typically get 30 days to respond, so it is a very fast process, especially when it takes 2 weeks to receive it in the mail. You have very limited time to respond to that. Once the company responds to it, only the company can respond to it because it's the company's petition. So once they respond, USCIS will look through the application, look through the statements made in the response and the supporting documents and decide, should this approval be reaffirmed, meaning it stays approved, or should we revoke it? And if we're going to revoke it, are we also going to find fraud or misrepresentation in it? So that's the NOI-R. And NOI-D is almost the same, except that USCIS has not yet approved the petition, but they think that based on the information and documents submitted so far, there's no way they can approve it because it's clear there were multiple filings or companies were working together. So this is before the H-1B is approved. But again, you only get 30 days to respond. And then once you respond, they may then deny the H-1B if the grounds of the notice of intent cannot be overcome. Versus an RFE, which is we filed the petition, but USCIS just needs more clarification. That's just your typical prove to us this is a specialty occupation, or prove to us that the qualifications of the employee match the job, or things like that. Those typically get 12 weeks to respond to. They're generally pretty run-of-the-mill. A lot of times after you respond to that, approvals can still be issued. So that's kind of the varying different types of notices that USCIS could send on these cases.
Emily, what if, I filed an H-1B last year, and I know that I filed in multiple companies, and I actually moved out to a different company right now. I'm working with Coca-Cola. Would I still get the intent to revoke? Because I'm not working the previous company that filed for multiple applications. Have you seen anything like that?
Yeah, very common, because a lot of people are aware that, the companies that were doing this are often fraud companies. They don't really have valid job offers. And so as soon as they get the approval of the H-1B, they move out of that company and move on to a regular company. That doesn't make the problem go away, because if that very first H-1B that was filed in the lottery gets revoked due to fraud or misrepresentation, that means that the employee is no longer considered to be counted in the cap. So the transfer that was filed by the next employer is subject to the cap, meaning it should not have been approved. So they'll go back and revoke the very first H-1B, and then if there's a finding of fraud, they will now, we generally don't see them go back and revoke the next H-1B from the other company, but we do see the next time that company files an extension or the next transfer that person files, they will get a notice of intent to deny saying, hey, you're not counted in the cap. So for people who've had that situation in the past and are aware of it, where the H-1B has not been revoked yet, you could consider going through the lottery again with your current employer in next year. Obviously, it's too late now, but so that you'll have that cap counted again in case the prior H-1B gets revoked due to fraud or misrepresentation. Other than that, we would recommend continuing to monitor the case status online of that original H-1B receipt number to see if a notice of intent to revoke or any kind of correspondence has been sent by USCIS. As the employee, there's not a whole lot you can do in responding to that because it is the company's petition, but you at least need to be aware of what's going on with that case so that if it eventually is revoked and there is a finding of fraud, you can potentially litigate that if the fraud is not on your part. If you had no knowledge of it, played no role in it, perhaps there's a way through litigation that you might be able to get that reopened and withdrawn instead of revoked due to fraud.
Most of the cases do end revoked, and there is also a chance, and you cannot, if once the H-1B is revoked, you will not be able to change to other status like H-4. You will not be able to change the status to B2. And there is a chance that when you go out of the country and then get the stamping, whether H-4 or maybe some other visa, you will be barred forever to come back into the United States. Now, this didn't used to happen previously, but in the past 1 year, we are noticing that even though the employer did all this activity, they are hitting with misrepresentation because the employee colluded with the employer in filing the fraudulent application. So, and if the person is hit with the misrepresentation, that's a permanent bar. You can never, ever come into the United States. There are limited waivers available and very less chance for you to ever come back into the United States. Even if you ever come back into the United States, the chances for you to get the green card is almost nil. I recommend that if you do have filed multiple H-1B applications previously, though, it may be worth for you to move out to H-4 or some other options right now, because before you hit with misrepresentation, you may want to consider complaining about these companies. I did put out a link out there for you so that you can complain against these companies. If you know any of these companies they have solicited you. I mean, they have contacted you to file, and you fell into the trap of those things. You may want to report this to the USCIS, because at a later date, if we were about to get hit with misrepresentation, this may become a difference for us. Look, I reported it. I was the person who did that thing. So I did put out a link there to report these kind of companies. There's a question that's coming from Mayor Kapordi. Will USCIS take off all the multiple fraud applications in the second lottery this year? Unfortunately, they don't. They want people to do fraud, and then they can throw them out of the country, though. That's what exactly. They laid a trap for all these people so that these people fell into a trap. And a lot of people ask this question, well, 400,000 people did fraud things. Just because of 1 million people do the act, it doesn't make it legal though. So please be aware of it. I would like you to contact, if you are a lawyer, if you have filed multiple applications, or if your employer has filed a multiple application, or if you doubt that your employer might have filed a multiple application, you may want to contact a lawyer. Anything else, Emily?
Nope, I think we can move on.
Emily, now the USCIS has issued a notification in the Twitter though. Previously, when people were getting laid off, we were a bit hesitant on moving them to B2 visa, saying that, hey, if you move to B2 visa, you want from B2 to move back to H-1B, you may have to go back to India to get the H-1B stamping. The reason is that they would say that since your B2 is not approved, we're not going to approve your H-1B. The bridge application is what we call as B2 application, since it's not been approved. But since the in the Twitter, the USCIS said that if you apply from H1 to B2, and then from B2 to H1B again, and the second application, if you're going to do the premium processing, the USCIS said they will approve the B2 and H1B change of status, which is a good news for the people. And for those people who are contemplating of losing the that have lost the jobs, you may want to file a B2 application. It's online. You can file it, a B2 application online. Are there any requirements to file H-1B to B2 application, Emily?
Yeah, the number one is you have to be in H-1B status at the time of filing, or within your 60-day grace period. So if you've waited and your 60-day grace period has already expired, this may not be a good option for you. So when you're filing that B2, you have to document that you were maintaining status at the time of filing. So you would submit your H-1B approval notices, your I-94, recent pay statements, and all of that to document that. You also have to show that your stay in the U.S. is intended to be temporary and has a finite end date to it. When you're filing a B2 in the U.S., generally 6 months is the maximum that you can request. And on that application form, it will ask you for the start date and the end date that you want the B2 to be effective for. So you can only do a maximum of 6 months. Also with the B2, you have to establish that you have a residence abroad that you do not intend to abandon. Now, generally, our office doesn't really provide any documentation of that in the filing. It's possible USCIS may issue a request for evidence for that, but a lot of times we've not been seeing that. So that's just something to be aware of as a possibility. And then be able to show that you'll be able to support yourself financially while you're in the U.S., because obviously during that B2 time, once you go out of H-1B status, you cannot work in order to earn a living and continue to pay bills and that sort of thing. Beyond that, you know, as you mentioned, once you do get the job offer to go back to H-1B, you can then file a change of status from B2 to H-1B, even though the B2 is still pending, as long as the 6 months that you've requested has not finished yet. So if your B2 is still pending for 8 months and you've stayed for 8 months, that is going to be problematic. So keep an eye on when that 6 month mark is that you've requested, and make sure you're either filing a change of status back to H-1B before that deadline, or you've left the country before that deadline.
Emily, let's go to the topic of the 485J supplement, which we at one point of time used to recommend mandatorily. That means that if you change the job while the 485 is pending, after 6 months, after 180 days, 485J need to be filed, because we have seen some denials when the companies have withdrawn the previous I-140 approval. But now we are saying, yeah, you don't have to file it right now. You can file it later on. What we recommend right now is to file the 485J supplement only when there is an RFE issued, and if there is an interview that is being conducted for you for 485J supplement. And Emily, is it absolutely needed that people need to file the 485J supplement before they join? Is there a timeline for them to file the 485J supplement?
No, luckily there is no requirement that you have to submit it before you join the new company. It's not like having to file an H-1B transfer. So you can submit it after you've joined, or wait until there's a request for evidence or an interview.
Emily, with regards to the 485J supplement, have you seen any denials of the 485 because the person has moved from company A to company B and later on filed the 485J supplement at the time of the interview or at the time when they issued an RFE?
No, as long as it's provided either at the interview or in response to the RFE, I've never seen a denial because someone did not submit it at the time the switch of employers actually happened.
You said one issue that if you want to be on H-1B, if you have to move to a company A to company B has to file the H-1B before you move to company B. But what if I want to maintain the H-1B? Is it needed for me to file the 485J before I move, or that rule is only applicable for H-1B?
That's only applicable for the H-1B. So the two things are separate. So you can think of your H-1B status and all those old rules that you've dealt with for so many years remain the same for H-1B, even though you've got a 485 pending. And then the 485 has its own separate set of rules, which do not require the supplement J to be submitted, even though you're filing an H-1B transfer to join that new company.
Emily, we're going to get into the topic which we disagree a lot on. If a person travels and if a person has an H-1B, let's say it's expiring in May of 2025, and they travel to India and come back on advance parole, the I-94 says that they are on advance parole, but we don't need to inform the employer and update the I-9 form. We can still use the H-1B that is there. We can extend the H-1B. We can transfer the company from company A to company B on H-1B. We can even move people from H-1B to H-4 if needed, or H-4 EAD if needed, though. Now, I consider that as an H-1B, and you consider that as an advance parole. Now, I know that there's a lot of difference between you and me and also a lot of other lawyers. Who is right according to you? Well, don't tell you're right just automatically.
Well, I mean, based on what we've been seeing of how USCIS has been handling this situation with the mass 485 filings that have happened really since October 2020, they're not creating any issues at all. They're not assuming that you're on advance parole now because you've traveled on advance parole. They're not saying that you have to only use your EAD now. Not seen any kind of negative consequences for someone who came back on AP and then continued the H-1B status after, even though their most recent I-94 is based on the parole entry.
So I feel that since you can extend the H-1B, you can change the status, you can transfer the company, you are on H-1B. If you barks like a dog, walks like a dog, acts like a dog, it probably is a dog. But of course, some of the lawyers say otherwise, you're on advance parole. Now, I'm not going to say that they're wrong. But there are some instances where, for example, if you are in adjustment of status and you came back in advance parole, and let's say your spouse is going for H-4 stamping, though, I want to be in a defensive mode, and there is something called automatic revalidation. You can go to Mexico and switch from yourself from advance parole to H-1B. It's very easy. You just go to Mexico, you have a margarita, you come back. When you come back, you show them the H-1B approval that you're working with this particular company, and you show them the pay stub. They can ask questions, are you still working for the company? And you say, yes, obviously you're working for the company, and then you're back on H-1. That's only rarely needed, though. It's not needed all the time, especially when your spouse is going for a H-4 stamping. I may want to do it. Or maybe you want to file one more 485. Maybe you're qualified for EB-1C, and then you want to upgrade yourself, or EB-1A, and you want to upgrade and file a fresh 485 application. Yeah, at that point of time, I may be an extra defense in going outside the country. At that point of time, these other lawyers, including Emily, I would say probably are right. But the rest of the time, I'm right that you are an H-1B even if you travel that advance parole. But people can disagree on that. And a lot of queries are coming on this. We still, irrespective of whether you believe on the theory of the people like Emily, where once you come back, you may not be an H-1B, or you believe me, you are an H-1B. But when you go to outside the country, you don't need to get stamping if you have an advance parole. What if you get a 221G? That puts into big trouble for you to come back into the United States. So just travel back on H-1B, and if you really want the I-94 that says H-1B, you can always do the Margarita switch. Go to Mexico, get an automatic revalidation. If you really want to get satisfied, no, Emily is right. It says advance parole. It's not an H-4, so I want that. It's not an H-1B. I want to say it H-1B. Well, you can do one thing. Come here, go to Mexico, have a Margarita, and come back. Because stamping is taking a lot of time. And unfortunately, even after everything is approved, by the time you get the passport in your hand, in India for the consulate, so it's taking almost like 4 weeks. So definitely coming back on advance parole is a better option. Anything else, Emily, before we go to questions?
Nope, I think we can move on.
Question that is coming, what is going on the recent US visa stamping within United States? Can we expect in September 2023? Looks like we should be expecting in before September 2023. The reason is that this administration is much more better in a sense, more immigration friendly to some extent compared to the previous administration. I have to say that this administration is definitely better. They would bring it back because it's also bringing back jobs to United States instead of having these consular officers go work outside the country. To have a consular officer work outside the country, it costs 3 times the money or even more for the consular officer to work in different countries than that of United States. So definitely bringing back the jobs, saving some money for the government is something that they should look into, and they are seriously looking into, and most probably the visa stamping will start before September in USA.
We had a couple of questions about USCIS sending requests for evidence for updated medical exams, the I-693, even though the priority date is not current. Final action date's nowhere near being current. Why are they sending them, and what should you do? There's no rhyme or reason to it. I think that they're trying to adjudicate these applications as far as they can while the date is not current. Before, they used to wait until closer to when the date was about to become current to send those RFEs. Now they're just sending them at random times, and you just have to respond to it and get a new medical and hope it doesn't expire while you wait for your date to become current, but you may have to get the medical exam again in the future.
Questions with regards that's come from Chintan. He's getting laid off. His perm is in the process. His max out date is less than 1 year. What are the options? Definitely very limited though. One thing you need to understand is that even if you go to outside the country though, you can still find a company that can file a permanent I-140 approval and still get permanent I-140 approval and then still get back, resurrect your H-1B. Leave about 1 week period within the 6 years period of H-1B for my sake. And then go outside the country and work for, stay there, get the labor and I-140 approval. I suggest that a lot of these consulting companies or the development companies, they do have branches in India. And if you do work for them in India, and they may do a benefit in filing the permanent I-140 approval here in the United States. So in that way, it's beneficial for the company, it's beneficial for you, and they will be able to bring you back. And then, of course, they will be able to make more money if you work here in the United States, which we already know that. So yes, there are options. So you can go to India and still come back if you have a labor and I-140 and resurrect your H-1B. So yeah, within this 1 year period, can you get a labor and I-140? Very tough. There are some companies that may have prevailing wage advertisements already done. If you go join those companies, they may do your labor and I-140 and you may get within 1 year if you're lucky enough. But if not, think of the option of working for a company that has branches in USA and branches in India that can file the labor certification while you're outside the country.
Minutecraft says, I got my GC EAD and currently working on my H-1B. If I choose to use my EAD, can I go back to H-1B in the future at any time for any unforeseen reason? My priority date's in 2014. So as long as you are working for the same employer that holds the H-1B approval notice, and that H-1B approval has not expired, even though you're using the EAD today, you could get back to H-1B by doing the margarita switch, as we talked about earlier. So that's you could travel to either Canada or Mexico for less than 30 days and come back showing your expired visa stamp or a visa stamp that's in a different category, and your H-1B approval notice that has an I-94 that's not expired for the employer that you're working for, and get a new I-94 putting you back in H-1B status. Once that happens, if you were using the EAD to work for a second employer or something like that, you would no longer want to work for that second employer because that would take you right back out of H-1B status. But that is the way to get back into H-1B. If your H-1B has expired and you're trying to get back into H-1B, the only way to do that is to have the new H-1B filed by the company through consular processing, exit, get the visa stamp, and come back, but you have to make sure that you have a valid advance parole at the time you're exiting and coming back in order to get back into H-1 status without abandoning the 485.
A question from coming from Sonam Kirky. What happens if employer does not respond to NOIR? Well, USCIS is going to take it and they will revoke the H-1B automatically. We see that a lot right now because these employers are running away. They just don't even respond to you. They don't even take your calls when they receive it. And they don't share the notice of intent to revoke with you. That's the reason Emily has been suggesting that please make sure that you create an account called My USCIS. Everybody this is applicable to. And put all your applications into that so that if there is any notification that pops up, you will be aware, you'll be in command of what's going on. At least you will know what's going on. So yeah, it is very common nowadays. These employers, they run away, they don't respond to that notice of intent.
Kunal says, I recently got my H-1B stamping in India, but my I-94 expiration is set to my passport expiration. Already applied for the new passport. How do I get my I-94 expiration updated to match my H-1B? Great question, and glad that you figured that out before the I-94 expires. A lot of people we find are unaware that if you're traveling into the U.S. and your passport is expiring before your H-1B approval notice is set to expire, even if you've got a valid visa for that whole time, CBP will cut short your I-94 to your passport expiration date. So you're only allowed to stay into the U.S. to the point that your passport expires, not to the point that your I-797 approval notice expires. So assuming that you get the new passport before your I-94 expires, you have a couple of options. So you probably have the valid visa in your passport already, so you could travel to your home country and come back in. And when you come back in with your new passport and the valid visa stamp in your old passport and your I-797 approval notice, you'll get a new I-94 that matches the end date of your approval notice. Or you can go to Mexico or Canada and do the margarita switch, stay there for a weekend, have a nice drink at the resort, and then come back to the US and get a new I-94 that way at the port of entry. Last option, which is most of the time the employers are not a fan of because it would require them basically to file the extension again before your current I-94 expires and pay all the filing fees and deal with an RFE or things, the typical things that happen during an H-1B extension. So usually travel is the best way to solve that problem. Just make sure you take action before the I-94 expires.
Questions from Raj Kumar. Changed employer recently, but got the USCIS site visit for my previous H-1B application. What can I expect now? As long as you worked according to the H-1B terms at the time that you work with that company, though, you don't have any problem, though. You should not get any problem. The only problem that comes is with these fraudulent H-1B applications where they file an in-house project, which we know how that is, and you never worked on the in-house project, which we know how that works out. Definitely, they will revoke the H-1B, and your all subsequent H-1Bs will be in trouble if that happens. So it should be taken very seriously, and they need to respond to the RF, to the site visit that is probably needed. It may be better that they consult a lawyer to respond to it properly, because if there is if the job is existing, let's say, for example, you're supposed to work in Coca-Cola, you did work in Coca-Cola until, let's say, until March of 2023, they can provide all the documents saying that, look, this employee worked until March of 2023, and then later on he left. And then I would even show them the H-1B approval of where you got it from a different company, and we'll show it to them saying that, look, after March of 2023, he moved on to a different company. Here is the H-1B approval. Here is a payroll. Then things should be very good for you.
Yearn City says, is the I-485 Supplement J considered as sponsorship? Because when you're applying for jobs, there's usually a question in the job application asking, do you require sponsorship? Do we need to say yes or no? The Supplement J is not sponsorship. It does not require the employer to take any action or to sponsor you in any way. Assuming that you're utilizing your EAD to work for the employer. If you're using your H-1B to work for your employer, then they would be sponsoring you for the H-1B process. But even still, the Supplement J is not sponsorship. All it is the company confirming that they've offered you a job that is similar to the job that you were originally sponsored for, and they just provide some basic company information. So no, you can answer that question no, assuming you're planning to use your EAD. Just make sure that as you're negotiating and deciding to accept that offer or not, make sure that they will, at least at some point in the future, be willing to submit a Supplement J in the event of an RFE or you get called in for an interview.
A question from Rajan. He is getting a editorship. He wants to take that one so that he could be qualified for EB1. He's getting a modest compensation. Can I accept the editorship? Unfortunately, you cannot accept the compensation. I would rather ask them if they're voluntarily it's available. That's one thing. The second thing is that would they pay your company which you are working instead of paying you? That may be something that you may look into. Or they can file a H-1B, concurrent H-1B, which I don't think so they will do it. So take a voluntary job, get it paid paid to the company that you're working, or have a H-1B concurrent file. These three are better options. But directly getting a compensation, even if it's moderate, which I know, you're making tons of money. This is little, nothing. You just want to do it for the passion. Do it for free if it's allowed.
Ansh says, I'm on H-1B and my visa stamp is expired. I've already got my visa appointment in India scheduled for July, but can I visit Canada prior to that visa stamping using my approved I-797? I do have a Canadian visitor visa. So yes, assuming your approved I-797 has a valid I-94 attached to it that will remain valid beyond when you're planning to travel to Canada, you can use automatic visa revalidation to go to Canada for less than 30 days and come back using your expired H-1B visa stamp and your valid I-94 on that I-797 approval notice, and they will magically revalidate your visa right there for that day at the port of entry and pretend that it's valid to allow you to enter back on H-1B, even though you have already submitted the visa application in India.
The question, does your office help in filing the EB1A application? This question is coming from SVD FXD. Yes, we do. We do help out in EB1As. You can contact our office. The lawyers to pick for EB1A will be Rebecca Chen, partner in our office, and also Vanita. These are the two lawyers that will do the EB1s, mostly in our office. So, coming Chanakya Bharati, hi Rahul and Emily, any lawsuits to speed up the APR under the GCEAD? Yes, you can file a lawsuit with against the USCIS to speed up the process of the advance parole. But I have to tell you that once we file the lawsuit, though, the minimum time it takes for the USCIS to approve the advance parole will be 60 days. So if you're thinking that, okay, we file the lawsuit, within 1 week you're going to get it, that may not be possible. But of course, there are it's not 100% guaranteed that you're going to be getting expedited. But if you want, you can contact Stephen Brown in our office. He's the litigation head in our office.
Jinkia says, my wife has the H-1B stamped. That's good till September 2025. The I-94 is valid till January 2024, and she was laid off in February, filed a change of status from H-1B to H-4 within the 60-day grace period, and wants to know, will she be able to join the new employer on H-1B while the change of status is pending? So currently she's not in H-1B status anymore, and she's not yet in H-4 status because that's not yet approved. She's in what we call a period of authorized stay, which is not exactly the same thing as being in status, although you are lawfully in the country and can stay here while that change of status is pending. What does that mean for changing status back to H-1B? So when we're in that situation, we would typically file the change of status noting that an I-539 is pending. We provide that receipt notice, and we state that the person's intended current status is to be in H-4, and they're requesting a change of status from H-4 back to H-1B. Now, once that change of status back to H-1B is filed, they cannot start working yet. You have to wait until the H-1B change of status actually gets approved. And it's possible that you might get a request for evidence on the H-1B asking for the H-4 approval notice before they will adjudicate the H-1B. We try to ask them to approve both at the same time when we're filing in that situation, and have been successful in doing that. But they might ask for proof of that change of status being approved, the one to H-4. And if it's still not approved by the time that you need to respond to that RFE, they may ultimately approve the H-1B for consular processing. Then she'll have to exit the U.S., apply for the new H-1B stamp, or in your case, she's got the H-1B stamp. So you might even want to consider just consular processing the H-1B. And then as soon as that's approved in premium processing, she can go out to Canada or Mexico and come right back and get back on H-1B because she has the valid visa stamp that is not yet expired, even though it has the old employer's name on it.
Question that comes from Ravi Kumar. His friend has filed 4 H-1Bs, 1 with a genuine company, with a full-time company, and 3 with the other companies. And a full-time company, which is a genuine company, got H-1B selected, and they're filing the H-1B petition. Will this cause any problem in the future? Until now, though, we haven't seen any problem if people have not filed H-1B with these fraudulent companies. However, though, looks like it's a trend right now that the USCIS may go after the people, even if they don't file the H-1B, because you colluded with the companies in filing the duplicate application when there is no job opportunity open. Why? Why they may take a different stand is because we were thinking that they were not tracking these duplicate applications properly. We were thinking that they don't know that the duplicate applications are getting filed. But we were wrong. Everybody was wrong. They were tracking from the beginning the duplicate applications. They have an idea how many people have filed a duplicate application. They published in their website that how many people filed for how many applications. Like 90,000+ people have filed for 400,000 applications. They published it. So we don't know if we didn't knew that they were tracking so dearly before, but now we know. There is a chance that they may take action on your friend because he used these 3 companies, which most probably we know there's no job opportunity for these 3 companies to file H-1B.
Chinton says a department of his company is getting acquired by another company, and it's been less than 6 months since the I-140 was approved. Will it still be safe to move to company B, the company that is doing the acquiring? So typically in an acquisition situation, if you're moving to the company that has acquired your department, it will typically qualify as what we call a successor in interest, because that company that's acquiring that department is acquiring all of the employees. They're continuing to employ the employees in the same job, same work location, and all of the details of the labor certification remain the same. So in that situation, even though it's been less than 6 months, I would expect that company A who's losing that department is not going to go and withdraw that approved I-140 because they want it to remain valid with company B so that company B can continue your process. So assuming there's no withdrawal by company A and company B, it truly is a successor in interest, you can move to company B, but company B still has to file an amended I-140 to document that it is a successor in interest so that you can keep that priority date and continue to use that same labor certification.
Lokesh asked this question, EAD and H-1B, which option is H-4 EAD or H-1B, which one is options better? Definitely H-4 EAD though, but because it has more flexibility, no location, timing, multiple jobs, a lot of flexibility in H-4 EAD. But I want people, if you're working for, let's say for example, you're working for a full-time company or any company, which is a genuine company, I want you to get the H-1B and get rid of it. I mean, it's good. Immigration lawyers are going to make money. The reason is get it and get rid of it. How do you do it? Let's say you're working for a company in H-4 and you never had the H-1B. It's always good to get the H-1B because later date, if your spouse needs to move on to the H-4 EAD, it will become easier if you have the H-1B. So you find the H-1B, get the H-1B approval, and switch back to H-4. You can file the change of status, but there's also something called Margarita switch. So let's say on October 1st, your H-1B starts. On October 5th, you can go to Mexico, you have a Margarita, you come back, and then you say that you're coming back on H-4. And all they're going to ask is, are you genuinely married with this particular person who has a H-1B? The answer is yes. Is the H-1B person doing a job? That's it, you come back. Now what happened is, you have this H-1B, you can always move to H-1B at a later date when you want to. Also, even if you are on the H-4 EAD, you can file an I-140 application. A lot of people are not aware that you can file a labor and I-140 application. So if you get the H-1B lottery, you get the I-140, at any point of time, you can switch your spouse to the H-4 plus EAD at any point of time. So I want that luxury that if you there are two couple, both of them should have the H-1B at one point of time. Both of them should have the I-140 approval. In that way, whenever we want to switch from wife to husband, husband to wife, we can do that. That's what I would strongly recommend. Vicky is asking a question that he's drafting a letter to the congressman, not counting the family members as separate individuals. You can draft, that's very nice of you. But Vicky, in the video though, we did draft a letter saying exactly what you're speaking about. It's been provided, we have given all the links so that you can use that if you want to. You can use that if you want to. It's there in the link that provided in the YouTube.
Vishnu says, my H-1B got selected with my employer, but I got laid off. My last day with the company is going to be in June. Can I still save my H-1B by premium processing to get it approved before they withdraw? So it's not enough just to get it approved before they withdraw. They need to get it approved and wait until after October 1st to withdraw if you want to be considered counted in the cap going forward. So you can just file an H-1B transfer within the 60-day grace period of October 1st. So if you just get the approval in June and then they withdraw it in July, USCIS takes that cap number away and you're not considered to be counted in the cap. So if the company is willing to file, get it approved, negotiate with them to see if they'd be willing to hold off on withdrawing until after October 1st so the H-1B can actually take effect, then you can file a transfer to another company and don't have to worry about going through the lottery again.
A question that's coming with Roshan Pasi. He's getting laid off, and is he eligible for compensation from the employer? Well, depends on what agreement that you had, what the employer is doing. But you said one thing, that your EAD extension is pending. If they want to give you the compensation, is it okay for them to give the compensation for you? Because your EAD is not extended yet. They can. The reason is that if the EAD extension has been filed before it's expired, you have up to 540 days to continue working. So absolutely, they can give a compensation. Pradeep is asking this question: can the H-1B extension be filed before 6 months of expiration window? Does the extension need to be filed within 6 months window? The answer is yes. The extension need to be filed only within 6 months window though. However, there are some times we can be creative in filing the H-1B extension before 6 months. Especially we do that when we want to get the H-4 and EAD approval for the spouse though. The reason is that we can file something called amendment plus extension. Let's say your H-1B is expiring in 2024 December, and your spouse wants to move from F-1 OPT to H-4 plus EAD, and then she needs to have a continuation of work. You can file something called amendment plus extension. When you file amendment plus extension, then you don't have to wait for the 6 months rule. Why should you file an amendment? Well, there are many reasons you can make an excuse to file. Let's say you're making $100,000. You can always say that the company can say that they're going to pay you $100,000 plus $5 or plus $10 and file an amendment. Is it required to file an amendment? No, it's not required, but you are just doing it for the purpose of the H-4 plus EAD to be approved faster, because as we know that if you file H-1 and H-4 plus EAD together, all of the things will be approved at the same time. So only for that reason we normally use, otherwise we don't use the technique.
Sama says, on H-1B, do I need to update USCIS about my secondary residence when my work location and LCA are based on my primary residence? Well, assuming you are living at your primary residence, that's your primary residence, and that's where you're working and your LCA is at that location, you don't need to do anything with USCIS since you're not changing your residence in any way. But if you are planning to, maybe your secondary residence is up in the mountains of Utah, and you decide you're going to go live there for the summer and you're working from home, then yes, an H-1B amendment needs to be filed to allow you to work from that other location for those 3 months of the summer. So it all depends on where you're actually working from. But if you are only working from your main residence, then no additional action needs to be taken.
Question that's coming. Who is the petitioner in the I-485 application? Good question. It is the employee though. It is the employee, but for some tactical reasons, we keep on saying that it's the person who filed the I-140. We keep on saying it for the discussion's sake, but you control the 485 application. The employee controls the 485 application. The employer does not control the 485 application. The question from Rohan Pasi was on OPT EAD, but it's expiring now, waiting for the GC EAD. Can this extension of 540 days possible? No, it has to be in the same category. OPT extension is different and STEM extension is different though. Questions from Raj Chiranjeevi. Assuming my H-1B got already revoked by my employer, can I transfer from B2 to H-1B? In case B2 gets approved. Here is the issue though. If the first H-1B that got revoked for fraudulent purposes, if that is your first H-1B though, you will not be able to move back to the H-1B. Remember what Emily said is that if the first H-1B has been revoked for fraudulent reasons, technically you're not counted towards the H-1B number. So since you're not counted towards H-1B number, then the subsequent H-1Bs have to be going through the lottery, not a change of status directly from B2 to H-1B without subject to the lottery. So you have to go through the lottery.
Sidhu says, can we travel overseas on advance parole while the H-1B extension is in progress with a 180-day authorized stay and then come back and continue H-1? So if you mean that your H-1B has already expired and the extension is in process, pending with USCIS, if you travel and come back on AP, you won't automatically continue your H-1B once that's approved, because you have to be in H-1B status on the day you leave in order to continue your H-1B status when you come back. So if your H-1B I-94 is already expired and you're staying in the US based on the pending extension, you're technically not in H-1B status. You're in what we call a period of authorized stay, which is lawfully in the country, but it's not H-1B status. So you would need to first get your H-1B extension approved, and then you can travel, come back on AP, and continue the H-1B.
Ramakrishna is asking a question. Multiple employers filed H-1B without my notice, and in the fiscal year of 2023, picked with 2 different employers. I did not accept any of them. Will it affect the STEM application? It may affect not just STEM extension though. They may put a bar for you completely to never ever come back into the United States. As such, does it affect the STEM extension? We have not seen that. As such, does it affect the STEM application? We have not seen it, but they may put a permanent bar on you though. What I recommend, since those companies filed without your notice though, I want you to take a preemptive action on these companies, report them to USCIS. Because if you report them to USCIS, you have an evidence that, hey, I did report them, I was not involved in it, and at a later date, if there is anything that we want to protect you, please keep a copy of this fraud report. And I have given a link, I have given a sample and exactly how to report in the web link that I provided in this YouTube or Facebook. There's a link we provided there. So if you can go there, just follow the fill in the blanks, you'll be in a good shape in filing, and you, at a later date, we may be able to defend you much better than if you don't file this fraud report. Because if there's a fraud, you're supposed to report it. I mean, if you are involved a part of it though, without knowing, then and now you know it, you should report it. Otherwise, you'll be in trouble.
A question about H-1B that it was approved for consular processing. If I wanted to change my status to H-1B in the U.S., is that possible? Do I have to go for stamping, or can I file a change of status within the U.S.? So it is possible to file a change of status within the U.S., but it's the company that has to do it, which means the company has to be willing to pay all the filing fees all over again and basically go through the whole process again. And it has to be the same company that received the consular processing approval. So if the company is willing to do it, yes, you can file a change of status, assuming that your current status is valid at the time of filing and will continue to the start date of the H-1B that you're requesting. Otherwise, you have to go for stamping.
Question that's coming out is, Sonam is telling, I think my employer haven't responded to notice of interview. How do we know if they've responded? Well, you can create a My USCIS account and then look into it if it's been getting responded to it or not. Normally, Sonam, what we're doing is that the employers don't share their notice of intent to revoke though. They don't share, they don't tell any information. Why do they don't share? Because there is a fraud involvement in it. Let's go back about 3-4 years ago when Trump era was there. We were getting RFEs left and right. We were getting denials for specialty occupation. God knows what kind of RFEs we were getting in at that point of time. But we did share with the employees. There was nothing there. I mean, here is the thing. We need your help in getting this RFE responded. Did we get everything approved? Of course, we got some of them denied, but that's a different issue though. Here, since there is a fraud involved in it, the employers are keeping very secret. Some of the employers are just disappearing from the face of this. I don't know where they are going. No response on the call, no response. There's been a report that I got a consultation with one of the guy where his H-1B was being filed by 5 different companies. And this 5 different companies filed for 700 people. They filed for 5 different companies with all 700 people with the same lawyer. Most probably the lawyer is going to go to jail, the employer is going to go to jail, and employer is going to disappear, but you may be affected negatively. Yes, I definitely, if the employer is not cooperative with you in showing the notice of intent to revoke or responding to it, you may want to complain about the fraud because you're a victim here if that guy is not sharing the things with you. And I've put a link where you can file a report of the fraud.
Hemchen says, my perm was denied and I moved to H4 with the EAD. The employer is refiling the prevailing wage now. And he wants to know, how long can I stay on the H4 to be able to use the H-1B once the new perm is approved? Do I have to go through the lottery again? So as long as your H-1B spouse is continuing to maintain H-1B status, you can keep extending the H-4 based on your spouse's continued H-1B status all the way till you have the I-140 approved, and then file a change of status from H-4 back to H-1B. As long as the I-140 priority date on your I-140 that you're going to be getting has not become current, then you can file that change of status, get a 3-year H-1B. You don't have to go through the lottery again because you're extending your prior 6-year limit based on having an approved I-140 now.
Sai Satvik Reddy, one of his friends, has filed H-1B with multiple different companies, got selected in one H-1B in the regular quota, not master's quota. And what is your suggestion of filing the H-1Bs? If you're filing for a H-1B, if you're not working for the company, do not file it. If you're already working for that company and you got selected from the lottery, you can file it. But if you're not working it, I would recommend that you consult a lawyer. If you have any thoughts of filing, please don't get into a permanent bar in coming into the United States. Any update on the second H-1B lottery? With all what's going on, Mr. Kulkarni, we are expecting second lotteries, right, Emily? Are we on the same page?
I do expect a second lottery, yes.
Yeah, but at the same time, we are still expecting in the second lottery also, there'll be a lot of duplicate filings that will be selected, which are not going to file. So we don't know if it's going to go to third, if not fourth, we don't know. But we do definitely, with the trend what's going on, we do expect a second lottery. And if that second lottery will be somewhere in July, we will come to know. Until July of 2023, we will not come to know, because on June 30th is the deadline for them to file for the lottery, file for the H-1B. So only in July we'll come to know.
Ramu says, I'm on H-1B status and my son, I'm guessing, is on F1 with OPT with his 1 year plus the 2-year STEM extension to be completed next year, and wants to know if his H-1B is not picked for the son, can he apply for an H-4 EAD based on the parent's H-1B? But the son is 23 years old. Unfortunately, no. Number one, the H-4 can only be obtained if your son is under 21. So once he turns 21, he's not eligible for H-4 at all. And then the H-4 EAD is only available for the spouse of the H-1B holder, not children of the H-1B holder. So unfortunately, you do not have the option of switching back to H-4 if he's not selected in the H-1B lottery himself.
Will they increase the H-1B cap next year? This question is coming from Kittu. The answer is it has to go to the Congress to increase the H-1B cap. Raj Chiranjeev has this question. My first H-1B has been revoked already. How do you know it's a fraudulent? Oh, well, I want to take a step back, Raj. H-1B can be revoked for 2 reasons, maybe multiple reasons, but 2 reasons are the main reasons. One, because the employer withdraws H-1B because you're no longer working for that company. If the revocation is because you're no longer working for the company, it will have no impact, none whatsoever at all, in your future H-1Bs. You're good. The employer is good. The employer is supposed to withdraw. And USCIS, instead of saying that it's been withdrawn, they say it's been revoked, which is surprising to us that they should use a different word. Now, if that's the case, you are free, you're fine, you don't have a problem. If the H-1B has been revoked because of fraud, now how do you know it's been revoked for fraud? Is if you have subscribed to the USCIS, my USCIS, they will tell you that a notice of intent to revoke has been issued. That's where the trouble will come. When the notice of intent to revoke comes in and then you see it's revoked, that most probably is because of fraud. But if you don't see any of the notice of intent to revoke, you just see it's been revoked, most probably you're in good shape. Anything else, Emily?
We'll take one last question. Ramalingam says, my 485 case status changed to interview scheduled. How long does it take for them to set the interview date? So the question would be, does it say they've actually scheduled the interview, or is it saying that case is ready to be scheduled for the interview? Because if it says the case is ready to be scheduled, that means they could schedule it anytime in the next 2 weeks to the next 6 or 8 months. Just depends on when the local office has interview slots available. And if they've already scheduled it for an interview, usually they give about 2 to 4 weeks notice if they've sent the interview notice already. So that would mean maybe in June is when the interview will be scheduled for. There have been a lot of reports in Houston recently that people are getting interview notices with like less than a week of notice. So it seems like they've had some mailing problems with that recently. But otherwise, you usually have at least 2 to 4 weeks of notice from the time that you get the interview notice in the mail.
Sudhir has filed multiple H-1B registrations. He's thinking of not filing. Definitely don't file. Definitely don't file. You are going to aggravate your situation in having a misrepresentation, permanent bar. GV has this question. He's H-1B picked up with company. I'm working for full-time for some time. I've also applied for H-1B with other company though. Will there be any consequences? I would definitely say in your case though, since you're working for the company, go ahead and file it. Will there be any consequences because you use the other companies? There may be, but there is nothing you can do about it. But this company that you're already working though, got selected. If I were you, I would file the H-1B and face the consequences when I have to. And I will report fraud about these other companies that file the H-1B when I'm not working for the company. And I have given a link at the bottom of the video so that you can report them. Anything else, Emily?
All right. Well, I think we're about out of time for today. Thank you, everyone, for joining us. And as always, we'll be back next week on Tuesday at 5 o'clock Central Time. And you can always join one of our daily conference calls and get the details for that by going to rnlawgroup.com.